Dear students, I'm Sahar Gul and I welcome you to the second part of Compromises, Arrangement and Amalgamation. Today's topic for discussion is Compromises, Arrangement and Amalgamation. The main aim of this lecture is to develop an in-depth understanding of amalgamations and the prescribed procedure for mergers and amalgamations under Companies Act 2013. Today, we'll also be discussing various aspects and conditions necessary for amalgamation in India under Companies Act 2030. After reading this lesson, you should be able to understand meaning and various types of amalgamation under the Companies Act, understand the prescribed procedure of these amalgamations, understand the role of judiciary in amalgamation of enterprises. Dear students, in this segment, we'll try to understand amalgamations by deep diving into the definition of amalgamation and understand the difference between the term merger and amalgamation. What is an amalgamation? An amalgamation is a combination of two or more companies into a new entity. A completely new entity is formed to house the combined assets and liabilities of both companies. The term amalgamation has generally fallen out of popular use in the United States, being replaced with the terms merger or consolidation, even when a new entity is formed, but it is still commonly used in India. Section 230 to 232 of the Companies Act 2013 with Companies, Compromises, Arrangement and Amalgamation Rules 2016 deals with the merger and amalgamations of the companies. And Section 234, read with Rule 25A of Companies, Compromises, Arrangement and Amalgamations Rules 2016, deals with merger or amalgamation of a foreign company with a company and vice versa. M.A. Weinberg defines the term amalgamation as an arrangement whereby the two of the assets or more companies become vested in or under the control of one company, which may or may not be the one of the original two or more companies. The shareholding in the combined enterprise will be spread among the shareholders of the two or more original companies. The Income Tax Act 1961 defines the term amalgamation as the merger of one or more companies with another company, or the merger of two or more companies to form one company. Difference between merger and amalgamation. In general, merger and amalgamation are considered to be synonymous with each other. However, there is a thin difference between the two. According to dictionary meaning, merger is the fusion of two or more enterprises, whereby the entity of one or more is lost, resulting in a single enterprise, whereas in amalgamation, neither company involved survives as a legal entity. Instead, a completely new entity is formed to house the combined assets and liabilities of both companies. As we have already discussed the important definitions of amalgamation, now let's consider the types of amalgamation. The two main types of amalgamation are amalgamation in nature of a merger and amalgamation in the nature of a purchase. To understand both these types in detail, let us go through them one by one. Amalgamation in the nature of a merger. As the name suggests, this is a type of amalgamation which works as a merger. In this, the transferee or the stronger company absorbs the transferor or the weaker company, and the two entities pool their shareholders' interest as well as the assets and liabilities. Businesses of both the companies continue to run under the newly formed entity, and if the shareholders of the transferor meet the minimum requirements, then they can become shareholders in the new company as well. Amalgamation in the nature of a purchase. If the shareholders of the transferor company fail to meet the minimum requirements and conditions, then they cannot retain their position in the new entity. And the amalgamation process takes place like a purchase, which is made by the stronger transferee company, wherein only the shareholders of the transferee company become shareholders in the new entity. Let's move forward and understand the legal procedure involved in amalgamation. Procedure. The prescribed procedure for mergers and amalgamation under the Companies Act 2013 is power to undergo amalgamation. It must be ensured that the companies undergoing the amalgamation have the power in the object of their memorandum of association to undergo such amalgamation. In the event of no such power is mentioned in the object clause, the memorandum of association shall be amended by the companies for the purpose of amalgamation. Approval of the draft scheme by Board of Directors. A draft scheme of amalgamation shall be approved in a board meeting of the respective companies. Filing of an application. An application is to be filed with the National Company Law Tribunal, NCLT, along with these documents: a notice of admission, an affidavit, a copy of scheme of amalgamation, fee as prescribed in the schedule of fees. The application shall also disclose to NCLT the basis of which each class of members or creditors have been identified for purpose of approval of the scheme of amalgamation between the transferor and the transferee company. In case there is more than one company involved in a scheme, such application may, at the discretion of such companies, be filed as a joint application before NCLT. However, where the registered office of the companies is in different states, there will be two tribunals having the jurisdiction over the companies. Hence, separate petition will be required to be filed for the purpose of amalgamation. Notice of meeting. A meeting shall be called as per the order of NCLT, and the notice of the meeting shall be sent to all creditors, members and debenture holders. The notice of the meeting sent to the creditors and members shall be accompanied by a copy of the scheme of amalgamation along with the relevant details and documents as mentioned in the section, if not already mentioned in the scheme. A chairperson is appointed for the meeting of the company, or other person who is directed to issue the advertisement shall file an affidavit before the NCLT in not less than 7 days before the date fixed for meeting or date of the first of the meetings, as the case may be, stating the directions regarding the issue of notices and the advertisement have been duly complied with. Mode of sending. The notice shall be sent by the chairperson appointed for the meeting or any other person as NCLT may direct, by registered post or speed post, or by courier, or by email, or by hand delivery, or any other mode as directed by NCLT to their last known address at least 1 month before the date fixed for the meeting. Website. The notice and other document shall also be published in not less than 30 days before the date fixed for the meeting on the website of the company, if any, and in case of a listed company, these documents shall be sent to the Securities and Exchange Board and the respective stock exchange where the securities of the companies are listed for publishing on their website. Advertisement. The notice of the meeting shall also be advertised in not less than 30 days before the date fixed for the meeting in at least one English newspaper and in at least one local newspaper having wide circulation in the state in which the registered office of the company is situated, or such newspaper as may be directed by NCLT, provided that where separate meeting of classes of creditors or members are to be held, a joint advertisement for such meetings may be given. Dispensation. With the calling of a meeting, the NCLT may dispense with the calling of a meeting of creditors or class of creditors, where such creditors or class of creditors having at least 90% value is required to agree and confirm by way of affidavit to the scheme of compromise or arrangement. However, in the event the affidavits have not been obtained from the creditors and the members, the meeting shall be conducted and the scheme is said to be approved by a majority of persons representing 3/4 of creditors or members. Approval of the scheme. The scheme is to be approved by a majority of persons representing 3/4 in value of the creditors or class of creditors, or member or class of members, as the case may be, either voting in person or by proxy or by the way of a postal ballot. The voting at the meeting or meetings shall take place by poll or by voting through electronic means. If 3/4 value of the creditors and the members agree to compromise or arrangement in accordance with the order of the NCLT, the scheme shall be accompany the creditors and the members of the company. Notice to regulatory authorities. The notice of a meeting of creditors and members along with a copy of amalgamation shall be sent to the central government, the registrar of companies, the income tax authorities, and the sectorial regulators or authorities as required by NCLT. The notice of the authority shall be sent forthwith after the notice is sent to the members or creditors of the company by register post or by speed post or by courier or by hand delivery at the office of authority. Report of the result of the meeting. The chairperson of the meeting shall, within the time period fixed by the NCLT or where no time has been fixed, within 3 days after the conclusion of the meeting, give a report to NCLT providing the result of the meeting of the members and creditors, and shall state accurately the number of creditors and members, as the case may be, who were present and who voted at the meeting either in person or by proxy, and wherever applicable, who voted through electronic means, their individual values and the method of voting adopted by them. Filing of a petition for confirming the scheme of amalgamation. Where the proposed amalgamation is agreed to by the members or creditors, or both as the case may be, with or without modification, the company shall, within 7 days of the filing of the report by the chairperson, present a petition to the NCLT for the sanction of the scheme of amalgamation. Where the company fails to present the petition for confirmation of the amalgamation, it shall be open to any creditor or member as the case may be, with the leave of the NCLT, to present the petition, and the company shall be liable for the cost thereof. Date and notice of hearing. The NCLT shall fix a date for the hearing of the petition, and a notice of the hearing shall be advertised in the same newspaper in which the notice of the meeting was advertised, or in such other newspaper as the NCLT may direct, not less than 10 days before the date fixed for the hearing. The notice of the hearing of petition shall also be served by the tribunal to the objectors or to their representatives, and to the central government and other authorities who have made representation and have desired to be heard in their representation. Order on the petition. Where the NCLT sanctions the amalgamation, the order shall include such directions in regard to any matter or such modifications in the scheme as the NCLT may think to fit to make for proper working of the scheme. No scheme of amalgamation shall be sanctioned by NCLT unless a certificate by the company's auditor has been filed with NCLT to the effect that the accounting treatment, if any, proposed in the scheme of amalgamation is in conformity with the accounting standards prescribed under Section 133. Filing of order. The order of the NCLT shall be filed with the registrar by the company within a period of 30 days of the receipt of the order. In addition to the said procedure, we need to understand the scheme for amalgamation of company with foreign company and power of central government to provide for amalgamation of companies in public interest. Merger or amalgamation of company with foreign company. This unique provision of the Companies Act allows two-way cross-border merger, unlike the previous Act of 1956, which allowed only a foreign company to merge with an Indian company and not vice versa. Now, the new Act allows both an Indian company as well as a foreign company to merge with each other, subject to the approval of Reserve Bank of India. It provides under Section 234 that the central government may make rules in consultation with Reserve Bank of India in connection with mergers and amalgamations provided under this section. It also states that subject to the provisions of any other law for the time being in force, a foreign company may, with the prior approval of Reserve Bank of India, merge into a company registered under this Act or vice versa. And the terms and conditions of scheme of merger may provide, among other things, for the payment of consideration to the shareholders of the merging company in cash or in depository receipts, or partly in cash and partly in depository receipts, as the case may be, as per the scheme to be drawn up for the purpose. A foreign company for the purpose of this section means any company or body corporate incorporated outside India, whether having a place of business in India or not. Power of central government to provide for amalgamation of companies in public interest. Subject to the satisfaction of central government, Section 237 provides for amalgamation of two companies into a single company with such constitution, powers, rights, interests, authorities and privileges, and with such liabilities, duties and obligation as may be specified in the order. The order may also provide for continuation of legal proceedings by or against the transferee company of any legal proceedings pending by or against any transfer company, and for such consequential, supplemental or incidental provisions as may be necessary to give effect to the amalgamation. In the opinion of the central government, every member, creditor and debenture holder of the transfer company before the amalgamation shall have the same interest in or rights against the transferee company as he had in the company of which he was originally a member, creditor or debenture holder. Thus, Section 237 provides for a faster process of amalgamation of companies, provided vested under this section to the central government are all spelled out in this section. You will also note the redressal mechanism for the dissentient shareholder's creditor in the case there is a reduction in his interest after the amalgamation as compared to what his interests were before, and the compensation to be paid in case there is any reduction of interest, if considered inadequate, can be agitated to before tribunal. The provision states that any person aggrieved by any assessment of compensation made by the prescribed authority may within a period of 30 days from the date of publication of such assessment prefer an appeal to the tribunal, and thereupon the assessment of compensation shall be made by the tribunal. The Company Act is dynamic and keeps on evolving. So moving forward, we will deliberate on the recent developments in law and the role of judiciary. Recent amendments. MCA notified the Companies Compromises Arrangement Amalgamation Amendment Rules 2022 to further amend the Companies Compromises Arrangement and Amalgamation Rules 2016 by notification dated May 30th, 2022. It has been provided that in a case of compromise or an arrangement or merger or demerger between an Indian company and a company or body corporate incorporated in a country that shares a land border with India, a declaration would need to be furnished declaring that the company or body corporate is not required to obtain prior approval under Foreign Exchange Management Non-Debt Instrument Rules 2019, or the company body corporate is required to obtain prior approval under Foreign Exchange Management Non-Debt Instrument Rules 2019, and the same has been obtained and is enclosed herewith. Role of judiciary. The provisions under the Companies Act constitute a comprehensive code in themselves, and under these provisions, earlier the courts and now the tribunal has full power to sanction any alterations in the corporate structure of a company that may be necessary to effect the corporate restructuring that is proposed. Mihir Mafatlal and Hindustan Lever are landmark decisions of the Supreme Court. Under the new Companies Act 2013, the High Court has been replaced by the tribunal. But so far, judiciary has played a pivotal role in the corporate restructuring activities in India. The court tribunal has these powers under the provisions of the Companies Act. First, power of the court to sanction the scheme. Second, power of the court to stay proceedings. Third, power of the court to reject or modify the scheme. Fourth, power of the court to order winding up of the companies or company. In Saraswati Industrial Syndicate versus CIT Haryana, the Supreme Court ruled that in amalgamation, two or more companies are fused into one by merger or by one talking over the other. When the two companies are merged and are so joined as to form a third company, or one is absorbed into the other or blended with the other, the amalgamating company loses its identity. There may be amalgamation either by transfer of two or more undertakings to an existing company. Dear students, the Company Act 2013 has brought many enabling provisions with regard to mergers and amalgamation. I hope you have developed a wholesome understanding of amalgamation, its definition, prescribed procedure, and different types established under company law and recognized by Companies Act 2013. With this, we wind up today's lecture, and I hope you enjoyed this lecture. I wish you all good luck.